One man's terrorist is another man's freedom fighter. Good evening and welcome. This is Face the Nation, and our topic of discussion today, unless it's already obvious to you what it's going to be, it's the anti-terrorism bill that is well proposed and to be enacted into law in Sri Lanka. It has not made its way to Parliament yet, but it's on the Gazette, and that means that eventually it will make it into Parliament, and if Parliament so chooses, could become law here in Sri Lanka. And to discuss this topic, of course, we've got experts in this field, as we always do on Face the Nation, introducing our guests for tonight. First, we have President's Counsel U.R. De Silva, advisor to the Ministry of Justice. He's here to tell us the logical thinking behind the drafting of this act and how, in fact, it will help Sri Lanka save Sri Lankans from the threat of terrorism. Thank you very much, sir, for joining us on our program. Also, we've got with us Dr. Gihan Gunathilaka, attorney at law, no stranger to the show. Thank you very much for coming on our show tonight. We've also got Bhavani Fonseca, senior researcher at the Center for Policy Alternatives. Thank you very much, Bhavani, for joining us on our show. And we've also got with us attorney at law, Hijaz Hizbullah, who is a person who faced the full brunt of the force of the Prevention of Terrorism Act, and who I believe is still fighting this matter in court. Thank you very much, Mr. Hijaz Hizbullah, for joining us on our show. So getting right into the discussion, of course, we need to understand the rationale behind this anti-terrorism bill. We've heard politicians speak about this matter, but of course, from a very eagle's eye perspective, mostly rhetoric. But let's first go to President's Counsel U.R. De Silva, who is an advisor to the Ministry of Justice, who knows the ins and out of the anti-terrorism bill. Sir, what really is the rationale behind this bill? I'm pretty sure you already know the criticisms against this bill. So here's your chance for the opening argument. You've got 2.5 minutes.
Because of Hizbullah, we got this act because he was tortured and suffered. He was suffering and he couldn't come out in the way that the people talk. And the harassment he got, all these matters had been considered according to the present bill. I think that is the very reason they thought that various areas should be covered. So first of all, this is 1979 Act. We were discussing this at length. Most of the people, they say it should be abolished. I don't think it is correct, because if we don't have any terrorism act, so what will happen next? We can't control those terrorism acts with the penal code or the criminal procedure code. So we have to have that type of act to curtail these or to control the people who are doing unlawful, unnecessary work against the government and against the people as well, and the property as well. So all these things are there. But the fact remains, this very old Act, 1979 Act, was implemented because of terrorists that are there in North. Because they were doing a lot of things, harmful acts to the country and to the people. Because of that, J.R. Jayawardena thought that there should be certain legislator to curtail them. So having considered the availability of the terrorism acts there in the other countries, they thought this is the best at that time. So people were that they were adhere to that, and they went on this. First, though it was called as a temporary act, it went on such a long time, because when the government changes, the people who are governing, they thought this is a best way of keeping that, because then they thought that it is helpful to our day-to-day life. That is the very reason they use it. And furthermore, the police took this act into their benefit, and when they think that they should arrest somebody, they easily put forward this Terrorism Act, and then they say we want to investigate. Even if they take a person under penal code for robbery, they say we are investigating this person about terrorism. So we are at the moment we want a detention order, and then subsequently he had been there for some time. So Mr. Hizbullah also, they have some here and there evidence, and they thought it fit to take him into custody, and they kept indefinitely. And thereafter, the most important thing, he was not allowed to see a lawyer, and he was not given the opportunity to see their family members. So those are the things that had been there, and people are talking about. We know that now. We know now he is not the person whom they wanted to have. So they took him into custody, but unfortunately he was there for some time. So during that period, they put forward various reports to satisfy the court, but because of lack of proper mechanism in the act itself, the magistrates or the high court judges, they couldn't do anything. Later, the Court of Appeal came in, and thereafter he was allowed on bail. That's a different matter. How the High Court and the Court of Appeal also took turns about that. Those are things that we have to discuss later. But the only thing is, in this particular situation, people were talking about the draconian law. So draconian in the sense, when he was taken into custody, the person is taken into custody, nobody can go there and discuss with him. No, even a lawyer. So here in this particular act, they have considered that fact. In the first time in the history, the lawyer's presence or the opportunity to defend him had been identified in the act itself. So thereafter, once he was taken into custody, all his family members should be informed. And then thereafter, magistrate has a major role to play. He can go at any time to the detention place and discuss with him. Those things were not available at that point. So he can discuss with him after getting the information. If he sees that he has been tortured, certainly immediately he can send that particular person to the JMO and then get a report, and thereafter he has the power to change the places as well. So those matters had been considered, and then the particular magistrate has the power to extend the detention orders or not. He has the authority, merely because they say that we want to extend after 3 months. After the initial stage of detention is 3 months in this particular new bill. So earlier it was not there. So that maximum period would be 12 months. So those things have been introduced. We will discuss later about the other things also, how the person being produced and the confession, how they are going to use those questions.
The procedures.
Those are very important areas. So what I say is, this is an act where earlier we are talking about draconian law, but here of course they have covered every aspect as far as the fundamental rights are concerned about the suspect.
Thank you very much, President's Counsel UR De Silva, Advisor to the Ministry of Justice. We now move our attention to Dr. Gehan Gunathilaka. Dr. Gehan, do you think this piece of legislation is as progressive as President's Counsel UR De Silva claims it to be?
So let's start with the comment that Mr. De Silva made about how the police have abused the Prevention of Terrorism Act. And we are here discussing this new bill because of that legacy. So the assumption here is that the police cannot be trusted with a piece of legislation that gives them extraordinary powers. Now, using that as a benchmark, let's look at this law. There are some changes that this law has introduced which not curtails police powers but enhances police powers. So for the first time in our history, we're going to have a piece of legislation that allows a Deputy Inspector General of Police under Section 31 of the Act to issue detention orders. Right? So now you move from a situation where the extraordinary power of issuing a detention order, which is vested with the Minister of Defense and often the President of the Republic who holds that portfolio, you're moving that kind of power, extraordinary power, to a DIG. And if I'm not mistaken, there are about 60 DIGs and 60 odd DIGs in the country, right? So now from a point where you have to actually go to the highest office to get a detention order, you can go to a mere DIG and get a detention order. And this is in a context that we claim police cannot be trusted with power, right? So that's number one. Then you look at section 61 of the Act. For the first time in our history, a senior superintendent of police is empowered with the extraordinary authority to issue directives to the public. And what are these directives? It can include prohibitions on entering a place, prohibitions on going onto a particular road, prohibitions on attending a meeting, and I think the clause M in that list says any specific act which is an open-ended invitation to restrict anything. And we're starting with on the premise that we can't trust the police. But then this law appears to be enhancing the powers of the police, not just to issue detention orders, but to effectively legislate. Because when you give the power to the police to make rules on who can enter a particular place, who can go onto a road, who can attend meetings, you're giving them rule-making power, which again is confined under ordinary circumstances to the President of the Republic under the Public Security Ordinance when he promulgates emergency regulations, declares a state of emergency and promulgates emergency regulations. So that's the current law. So the current situation is a situation where the highest office bearer has certain extraordinary powers, and now we are decentralizing that and vesting those powers in the police. But we began this conversation by saying that the police can't be trusted. The police can't be trusted with more powers, and that's why we need to replace the PTA with the ATA. So I think that there is a fundamental incongruence, if that is in fact the intention, because the ATA enhances police powers and moves us from this de facto police state to a de jure police state. Because for the first time, the police will be deciding who is detained, and the police will be deciding what kind of directives to issue on the public. So I think we need to revisit this if that's the fundamental sort of purpose behind the Act.
Thank you very much, Dr. Gihan Gunatilaka. We now move our attention to Bhavani Fonseca, Senior Researcher at the Center for Policy Alternatives. Bhavani, what is the opinion of the Center for Policy Alternatives? Because that institution has been extremely involved in when legislative enactments are being passed in Sri Lanka, constitutional enactments, especially the PTA, been quite critical about the PTA. The PTA is finally gone once the ATA comes. Haven't you achieved your goal?
Well, the whole point of legal reform is that it should be addressing the needs of the people. It should be respecting fundamental rights. It should be protecting the citizen. When you have a piece of legislation that is inherently abusive, can be used to target particular communities, minorities, critics, political opponents, there is a fundamental problem there. Now, the PTA has been there for decades, nearly 44 years. It came as a temporary provision and now it's been there for a long time. The reason CPA and many others have been calling for its repeal is it just doesn't serve the purposes in terms of protecting the citizen of Sri Lanka. What we have seen is it has been used as a weapon rather than a protection for the citizen. So we've been calling for the repeal for decades. But what we get in place of the PTA, the proposed legislation, on the face of it seems extremely alarming. It's a draconian piece of legislation. And I think we can go into specific issues in terms of safeguards that are meant to be there. I mean, one aspect I'll be very clear is the confessions is out. That's, I think many of us will say, is a welcome step in this piece of legislation. But on the whole, if you say this is to replace the PTA, then one expects it to be better, not worse. What it does is provide broad powers to the executive. The president really can issue various orders, we'll go into it during the course of the show, with very limited checks and oversight. So it's very worrying. The other dimension is the broad definition of terrorism. If you really look at this, anything could be construed as terrorism. This conversation, this discussion, because there's a particular clause on media freedom, could be considered terrorism. So I think we need to really understand what is this proposed law trying to do. If it's meant to be better, I think it's then a failure. So you asked what is CPS position, are we happy? No, we are not. If this proceeds, we will have to really look at challenging this. But I hope before that, it gets to that stage, the government realizes the problems inherent in the draft and withdraws this bill, have a proper process of consultation, explain to the citizen what is meant by this. And as far as I know, there hasn't been any conversation within Sri Lanka, at least where people are privy to what is the reason behind this particular law. I mean, they talk about we have to replace the PTA, but why this? Why the reason for particular powers to the police, to the executive arm, to the military, and really with limited checks and balances and safeguards. So there has to be a conversation, there has to be a clear process, there has to be accountability. And Charlene, let me just also say we are having this conversation in the backdrop of citizens demanding for better governance, government, political accountability. We need to do better than go back to repressive laws, which is becoming the norm now, not the exception. We have to push back on that.
Bhavani, just one clarification. You said we need to understand the purpose behind this law being implemented. As far as I know, or at least what I was taught, was that when you want to look at the purpose of a certain act, you look at the preamble. So is your argument that the provisions in this act don't really stay true to the preamble of the act?
So let me ask this question. The whole point, the purpose of getting this legislation is meant to address terrorism. What is terrorism? If you look at the definitions, it's extremely broad. And one fundamental issue with any piece of law is that you have to be very clear, you have to be precise, you cannot have vague terminology, you can't have language that can be open to abuse by individuals. So, you know, any law, and it's not just this law, any law, you have to have those basic principles in place. Now, what is also the whole issue of terrorism? When we had the debate around 2018, 2019, when the earlier counter-terror law was being proposed, the whole premise was we need terror laws. Easter Sunday attacks happened when we had the PTA in place. So one needs to also question, we have the PTA in place, terrorism happened, it didn't deter that. So what is the purpose of this law if it's to address terrorism? How is it supposed to address that? So that conversation is extremely important if you're to have such a broad law. What is this definition of terrorism? Who is it that falls within those definitions? Who decides those definitions? Who implements the law? And a very basic question, who benefits from this law? Who really benefits from this law? So I think those fundamental questions need to be asked.
Thank you very much, Bhavani Fonseca, Senior Researcher at the Center for Policy Alternatives. Of course, Bhavani, you mentioned the April 21st attacks, but of course there have been many other attacks like the incident in Digana, for example, that was also a terrorist attack of sorts, or if not definitely a terrorist attack. But we'll get into those or into the conversation regarding those incidents as we progress through Face the Nation tonight. Finally, of course, we have Attorney at Law Hijaz Hizbullah. It's very rare that we get a panelist being the subject of the discussion in the opening statement of one of the other panelists. But sir, of course, you're here under exceptional circumstances as a person who has lived through the atrocities that the PTA could inflict upon a person. And I believe that there is no better person to speak about this new law that is being brought to repeal the PTA and replace it.
Thank you, Sharan, for having me. And I'm glad that my arrest and detention has raised awareness about the issue of the Prevention of Terrorism Act and its draconian features. But I'm also saying I'm disappointed if that awareness has resulted in the anti-terrorism bill, because this is not the way forward, and this does not address those grievances and issues and problems that we faced in the PTA, and which I think my legal team, which included Dr. Gehan Gunathilaka and people who supported me like Bhavani, spoke about. So this is not what we were fighting for. Not the ATA is not what we were fighting for. And what I'd like to talk about is that there are a few good things in the whole act and as a detainee. And I think I can say there's only one thing that I find very positive, and that is the opportunity for a detainee to meet the magistrate every 14 days. And that's a very positive development. Of course, the magistrate cannot do anything about it, right? Even if there is instance of torture, the magistrate cannot change the place of detention, which is there in the current PTA. But in the ATA, that power of changing the place of detention cannot, the magistrate has no jurisdiction, and therefore a detainee is not going to come out and tell the magistrate that he has been tortured, because he knows he's going back to the place of detention. So if at all, that is the only positive thing, that the opportunity for a detainee to meet the magistrate every 14 days.
So, Mr. Hizbullah, what's really the benefit of the detainee meeting the magistrate if he can't appraise the magistrate of any torture, or if the magistrate can't do anything about it? Is it just a cordial discussion to say, hey, hi, you're still alive?
It's very psychological, because once you're a detainee, you are 24 hours a captive, subject to questioning, subject to interrogation. And interrogation, there's no one monitoring what time and the circumstances in which the interrogation takes place, or the timings that the interrogation takes place, whether the person who's being interrogated, detainee, has adequate sleep, whether the food has been given properly, whether he is able to communicate with his family. All those issues, he has absolutely, he's at the hands of the people who are interrogating him. They are the ones who decide whether he gets all those also. So, for example, I walk into a room and there's a person who's interrogating me, and then that person interrogating me also decides whether I use the toilet,
Whether you eat,
whether I eat, whether I call my family,
whether you sleep,
whether I sleep. So that's a very, very, very oppressive circumstance. And then also you have the situation of a detention order. So obviously, if you're under the ATA, you will have a detention order, and in the PTA it was for 18 months, reduced back to 1 year in the recent amendments. So you will be there for 3 months, subject to this process of meeting the same group of people, living in this. So on the 4th floor, meeting the same CID officers, going through the same process for 3 months, seeing nothing new or nothing different. So in that context, the ability to meet a magistrate and to speak to a magistrate and tell the magistrate what's going on certainly is an important thing psychologically for the detainee, for him to know that there is a judicial process and there is a legal community and a legal system that is watching his welfare and whom he can reach out to, because that's part of the message that the police gives to a PTA detainee, is that your life is over. Because under the old PTA, a DO goes on for 18 months. Then you're produced before the magistrate. Magistrate has no power of bail. He remands you. Then you're in remand custody until the Attorney General decides whether he indicts you or not. Even if that decision normally takes about 3 to 4 years. The indictment takes 3 to 4 years. Mr. U.R. De Silva knows that as a criminal defense lawyer, top criminal defense lawyer. He knows how long the AG's advice takes. So 3 years he's there. So 1.5 years plus 3 years, 3-4 years before the indictment comes. The indictment, and there's no chance for bail, the trial takes 13-14 years. And even yesterday or day before, 3 three persons who were in custody for 14 years were released acquitted. So 14 years, 15 years of your life is wasted in this process, and you come out acquitted after 14 years. So that's the message that the CID tells a detainee. Look, you will be staying here with us for another 13 to 14 years. So cooperate. So that's how they elicit confessions. So it is in that context, that these meetings with the magistrate are important. But coming back to whether this law actually serves any purpose, not only Babani is right in saying that the definition of terrorism is broad, but also the definition of terrorism is low. The threshold is extremely low. Now, if you look at the international standards of terrorism, there is a very high standard. The intention, the mental element has to be very high, provoking a state of terror, terrorizing a population, intimidating a population. It's a very high mental element. The offences are very restricted. The acts are very restricted, and the wrongful acts are also of a very serious nature. But the bill that we have before us is does not meet those standards at all. I'll just read one little section before I finish. Causing serious obstruction or damage to interference with essential services or supplies. That's a strike. If you go on strike, you committed this offense. So it's an extremely low standard. So although we have called it terrorism, this is what terrorism is this?
Thank you very much, Attorney at Law Hijaz Hizbullah. We now open the floor for questions from our journalists. And judging by the opening statements that were made, there might be quite a few. So we've got some capable journalists. Of course, firstly, on my right, senior journalist Niresh Eliathambi. Thank you very much for appearing on the program. And also onto my left, Attorney at Law Ravindu Jayakodi, who would have a good understanding of this law as well. So the floor is open for questions. Let's start off with Niresh.
Thank you, Shalan. So, Mr. U.R. De Silva, just one question to you to start off. This particular bill is very surprisingly, it has included the death penalty in it. Now, at a time when globally it's becoming more and more recognized that the death penalty is not a good punishment at all, and fewer countries are using it, and at a time when Sri Lanka itself has not carried out formal execution in nearly half a century, what was the need at all to include the death penalty in this?
Certainly,
yes?
It should not be there. So, as you quite correctly pointed out, now Attorney General himself goes to the Supreme Court and say that we are not going to have this death penalty for hereafter. So, the particular death penalty is there in penal code. It's still there. Once he is being convicted, the High Court judge says you will be sentenced to death. Thereafter, the Poisons Opium Dangerous Act also, it carries death penalty over 5 grams or now over 10 grams like that. So it is there, but for the sake of putting that, they have put, I don't think it is correct. As you said, we should be open and we should say that this is the maximum punishment, not the death penalty. We know very well that we are not going to implement that. So why we are going to have that? My submission or my idea would be that it should not be there. And the other important thing, as you asked, the 20 years deciding factor for the Attorney Generals to keep a person guessing for 20 years, I don't think it is correct. So they can have 5 years as suspended term of that type of a thing. But 20 years is not good and it should not be there. So this is a bill we are we are discussing, and our panel is also making some suggestions. It can be considered in the Supreme Court, and then finally we will have a good legislation. That's what we also wanted to have. But what we say is, as Hizbullah says, now the magistrate's power, I think it has been given for the first time. The magistrate, without informing anybody, he can just go there and see that and have a private discussion. That particular word is used there, and then he will get the information from that detainee, and if he is satisfied or if he sees that there are injuries, then he can straight away, or if he can't, the person says about that, and he can send that person to the JMO, and once the report is available, and then if that person says I have been tortured, then thereafter the magistrate has the power to listen to the prosecuting officer as well as the detainee, and then change the place. It is clearly stated there. He can change the place. He can give an order to change, and he can ask not to the particular officer not to go there and interrogate. So those things
I think Mr. Hizbullah had a different opinion on that. You can't change the place?
Section 29 doesn't provide for the place to be changed. And it only allows for the police officer who previously had access to the suspect shall not have access to the suspect.
Right.
But if I may share something from what I have learned from my experience as a detainee, these incidents of torture and these incidents, I saw assault happening in the CID, right? It's very controversial to say that on media, but it's a fact. It happened, and I saw this. But the clever or how it was done was that those detainees, when they were taken out of those cells at 2 o'clock and 3 o'clock in the morning, it was not the same officers who were doing the investigation. It was someone completely different who he did not know who it was. So even in pinpointing and making saying who this officer, they have difficulties there. They have difficulties there. So that's why I feel that these provisions, while the opportunity to meet the magistrate and to have yourself examined by the JMO is a salutary thing, it might also be meaningless because of the fear element of reprisal for having spoken to the magistrate.
So, President's Counsel De Silva, you can change, can't change?
That's right. What I am saying is, this is the first time it has been given. You can talk the way that the police are handling these matters, though we can't do anything in this particular enactment. So what we say, the police in not only this PTA Act, in other acts as well, when they take the person into custody for robbery, they put heroin and produce before the magistrate and say he is under Poisonous Opium Dangerous Act. So for that purpose, are we going to abolish the Poisonous Opium Dangerous Act?
Just for a finality.
What I'm saying is this. May I say this? What I'm saying is this. We have to go in this particular legislation and see whether on paper it has been recognized and given the opportunity. Whether the police are doing it in a proper way or not, I am in agreement with that. I know personally how the police are behaving.
Just to bring a finality to the question of whether a detainee who speaks to the magistrate can have his place of detention changed. Can't?
Yes, can, because his lawyer is there. He can make submissions and ask the judge to do that. So the magistrate is bound to do that. Otherwise, there is no purpose of having this.
Mr. Hizbullah, do you agree?
That even if the magistrate wants, he can remand the person without keeping.
Yeah, there are provisions.
Without keeping him there in the detention orders, and he can remand that person instead of that, because he knows very well that he has been harassed. And there's a report. Now, if the magistrate is going to ignore that and keep that person in the same detention place, there is no purpose having this act. So, my personal view is that the magistrate has the power. It has been given to magistrate, and the important factor, without notifying anybody, he can just go there. And the other important thing is Human Rights Commission. they within 24 hours they should be informed.
No, sir. It was changed to 72 hours. I was just about to ask that. This act changed this time frame to 72 hours. Why are we delaying this?
No,
Notifying the Human Rights Commission is not a problem, because
Right.
Human Rights Commission is also an independent commission in this
that's
country.
correct.
So why did this act specifically delay this time, increase this time
In
frame?
the sense that 24 hours, within 24 hours they should be informed, but they can go without any delay, they can go, but not, the maximum period would be 72 hours,
Exactly.
not after 72
But
hours.
then it
So that
gives the time frame. Why increasing it? What's the purpose of increasing it? You can just notify the Human Rights Commission. Nothing is going to change.
the only thing is, now there is a procedure of conducting investigation also. No, they have to take some material, immediate material to their hand, and thereafter only they can do some other investigation work. For
what's
that
the influence?
purpose, now that is why we say 24 hours, 48 hours, for the police to take maximum out of this particular person and get the investigation progress. That is the very reason. But the fact remains, Human Rights Commission should be given the detention order, and why they have been detained is there in that particular report. If that report is not available, magistrate can query from the police why you have not produced that particular document before me. So those factors were not there in the earlier act. So that is why I say this is a progress. We can find fault with lot of things if you go into detail. But at this stage, are we not satisfied the way it has been considered at this stage?
The procedure.
And we want to improve that. Certainly we want to improve it. But we have come more than enough to this point, and that is why we say we are in agreement with the particular areas, but we have to improve by getting the material from the people who are ready to, genuine people, not only the people who are saying we can't do anything, we should ask the government to abolish. No, that is not the way of handling it. We should come out with those people, they don't come. The Bhavani state some material point, and my learned friend also say those matters should be considered. But the fact remains, some people, they say, merely because they know that they can't, every day they can't come to the roads and harass the people and sabotage the day-to-day work and damage the properties. So if we are allowing them to do whatever they want merely because their fundamental rights are available, I don't think it's correct. Fundamental rights are available till they say, ඔබගේ මූලික අයිතිවාසිකම් තිබෙන්නේ අනිකාගේ නාසය දක්වා පමණයි. So that is there. Section 15 is very clear about, the Article 15 is very clear what are the things that had been considered and not fundamental rights. So that is why I say we have to look into this matter and we have to improve this. I am in agreement with that.
Sir, now if we are talking about improving the act,
Ravindu, can we just go to Dr.
Yes.
Gehan on this fundamental rights issue now? One of the base arguments where people say that this law, or people who criticize the law on, is that it impinges fundamental rights, and that's what people are gearing up to go to the Supreme Court about. Recently addressing the media, Dr. Vijayadasa Rajapaksa also said that if there are any infringements of human rights, that he himself will support people who want to take this to court. So Dr. Gehan Gunathilaka, based on what President's Counsel UR De Silva said, that people must not be allowed to come to the streets just because their fundamental rights allow it, because they must not be allowed to affect the majority of the population, or at least the community of the population, adversely, because their fundamental rights stop at the nose of another person. How would you respond to that?
So I think going back to the objective of this act is ultimately meant to replace the PTA, because the PTA has certain problems. All of us, the entire panel agrees that the PTA has problems and need to be replaced, right? Some of us think it should be repealed and the replacement is not necessary. Others say it has to be replaced. But we all agree the PTA is bad. So let's just break that down a little bit. The PTA is bad because of what? Number one, it doesn't have a definition or scope for terrorism, right? Now, does this law solve that problem? Success or fail? Fail, because the definition that this law offers is so broad that even acts of legitimate protest that is designed to compel a government to do something or to abstain from doing something under Section 3 of the bill will be treated as terrorism. And then you have companion offences. Even a publication or statement that encourages those to participate in such protests deemed to be terrorism under this act will also become an offence. Failure to report someone participating in a protest of that nature or preparation to participate in that protest, that will also be an offence. So once you have a faulty definition and scope for terrorism, everything else flows from that. So on the first count, it fails. On the second count, the PTA permits long-term detention up to 12 months now with the amendment, and the ATA also permits 12 months. So fail. And I would say the ATA is worse, because at least under the PTA you have to go to the president to get a detention order. Under the ATA you go to a DIG. Defense minister, but the president who happens to hold that portfolio. Under the ATA you go to a DIG. So it's worse. Number 3, confessions. Now that's one place that you can concede that the ATA is better, because confessions to a police officer is admissible under the PTA. However, under the ATA, you have to make a confession under the magistrate, and there are certain protections that are offered. But then you go to Section 104 of the Act, and that is a sneaky little provision. And I want to just reiterate what Hijaz mentioned earlier, that a trial typically takes 12 to 13 years to be completed. That section says that if criminal proceedings have already been instituted against someone under the PTA, despite the fact that the PTA is repealed, it will be the PTA that determines procedure, evidence, the way the trial is conducted. So the PTA will be repealed, but will be haunting that individual for the next 13 years, right? So on procedure, it fails as well. On things like, production before a magistrate, let's all admit that the ATA is better, because it ensures that a suspect is produced before a magistrate within 48 hours, and as Hijaz mentioned, every 14 days. So there are some positive aspects to this bill. But if you look at the overall scheme of this bill in terms of the restrictions it imposes on fundamental rights, it fails to replace the PTA with a better law. And if that is the preambular purpose of this act, it fails. And I think that is why there are so many people criticizing this law. Ultimately, it doesn't succeed in what it sets out to achieve.
Dr. Gunathilaka, on the detention orders issued by the DIG, now as you said previously, under the PTA, the detention order will be issued by the President or the Defense Minister.
Defense Minister,
So, but then the DIG issuing this detention order, don't you think it carries more responsibility on the DIG to look for the well-being of this detainee, because he will be kept under detention order issued by him?
Actually, it is the opposite.
On the ground aspect, he's more close to the police and everything, the DIG.
I would actually argue the opposite. When there's a president or a defense minister issuing a detention order, he is answerable to Parliament. He is answerable to the cabinet of ministers. He is answerable to the people. A DIG is one of maybe 60 odd officers that might be issuing a detention order. There is no accountability there.
But Dr. Gunathilaka, when the defense minister was issuing detention orders, I believe it was the criticism of civil society, maybe even you included, that a politician is issuing the detention order. How do you suggest we solve this conundrum?
We are not endorsing detention orders. We're not.
So you are just blanketly against detention orders?
We think, my position on detention orders is that you have to always permit a judicial officer to exercise judicial power. You don't usurp judicial power and vest it in an executive official, right? So that vesting is an extraordinary exercise of changing the usual status quo, where a judicial officer will exercise judicial power and use judicial competence to decide whether or not someone should be remanded, released, or given bail, right? Now you give that power to an executive official. Under extraordinary circumstances, someone might argue the highest office will be the one that exercises that.
Deciding on it.
Right. So because it's such an important deviation. So, leaving aside the fact that detention orders are repugnant, the vesting of that power in a DIG is much worse. Suddenly you have 60 odd people being able to exercise essentially judicial power. So I think there's a fundamental problem with detention orders. And for 3 months, even under this act, a magistrate is precluded from considering whether this individual actually ought to be released or discharged or remanded.
The discretionary power is vested on the DIG.
Completely.
So there seems to be a general consensus here that our average DIGs lack the qualifications perhaps or the temperament to carry out a detention order with responsibility.
I wouldn't say that. I think I wouldn't take on a sort of ad hominem attack on DIGs per se. I think it's just a bad idea to vest powers in police officers who are in charge of that investigation with also the power over a person's liberty. That is why you have an impartial officer to consider all sides without having a vested interest. That's why you go before a judge. But if a DIG is given that power, essentially you're giving up that power to someone who has a vested interest in the investigation. So I think it's not just about the competence of those officers. I don't mean to, disparage those officers. It's about the structure. It's about who gets to decide on these things. It should be an impartial officer, and that is why we expect magistrates to exercise those powers.
I'm sorry, I want to interrupt my friend.
Sure.
Because he must go through the section 40 as well. So if the person is not satisfied the detention order, immediately he can send a review board, that is called the
Board of Review.
Board of
Review. So that is there to consider his detention is illegal or should be there for some time or 3 months or not. That is like a judicial forum where the Secretary to the Ministry of Defence, so-called that now he is concerned about the Ministry of Defence not issuing detention orders. No. The Secretary to the Ministry of Defence is there and eminent two people are there to consider whether the particular DIG without any material, he has issued the detention or not. And then, if they are satisfied with that, Section 40 very clearly said that he can ask the person to be remanded or remove that detention order, or then he can affirm the detention order. So that is also considered. My request would be, this is a particular separate law. This is not, we are not discussing about a penal code. We say the magistrate should have the powers, he should be able to do the necessary things. The criminal procedure code is there. So that is the normal law. This is a separate law where whether they are being convicted or not is a different matter. But the fact remains, they are being taken into custody for the purpose of investigating the terrorism purpose. Whether they have done some terrorist act or not. That we can't say it's normal.
The President's Council, the main issue again is what is this terrorist act? You can define anything according to this act. You can define any uprising against a government as a terrorist act.
That is why I say this is what they have stated in the particular legislative enactment. Now, if you go to the EU code also, they have not defined it. They have considered what are the things that can be considered as terrorism. So, in most of the outside the world, they have considered in bribery also, our bribery act, it does not define bribery is what. They say it includes. So various things. That is how it goes. We can't just say this is what terrorism. They say these are the areas we are considering, and if the people are doing this type of act, not only act, if it comes to the particular offences, it has been clearly stated, murder or sabotage, so damage in the property, those are the things that had become. And in that context, if they have been taken into custody, ultimately they will be discharged or acquitted. But at that point, we can't say they are innocent. The presumption is there. But when the police take these people into custody, they think that they have some material. DIG issues the detention orders because he thinks it fit to issue a detention order because he after considering the facts given by the police officer. If we, for the sake of issuing it, we can challenge that before the Board of Review, and thereafter the lawyer can go to Supreme Court. The lawyer can go before the magistrate and inform the necessity of remanding the person. Those material were not available earlier.
PTA.
Now it has come. Why we are criticizing without considering these things?
Bhavani, do you think that this is a positive, turnout of events as far as the provisions that President's Counsel U.R. De Silva pointed out?
So can we just pause here for a second? We are going on the assumption that just because there are a few things that may seem good, we all have to kind of jump with joy and say, great, the government has made some progress. Now, Mr. De Silva raises some very valid points in terms of, there are some, I would say, marginal improvements compared to how the PTA has been implemented. But I think we also miss a very fundamental question, that we have such a rotten system in place that some of the colleagues here have alluded to, where there are officers who feel it's their right to abuse and use particular methods. I mean, you mentioned yourself, maximum possible power to extract information. So when you have that mindset, you then have to have the strongest, most robust safeguards in place to ensure those practices are not further entrenched, because they are entrenched. It's not just Hijaz. If you speak to many who've gone through the system, who are still in the system, that's a standard response, that it's normalized. These systems, these terror laws, legitimize certain practices. So I think when we are at this moment, and we miss this fundamental question, when we are at a moment of reform, I think it's very important to take a step back and not just jump with joy saying, okay, a few things are there, so let's then go to the Supreme Court, because I think we need to also understand the Supreme Court, if one challenges, can only look at the constitutionality of provisions. It can't fix the entire system. I mean, everyone rushes to the Supreme Court. The minister himself says the Supreme Court will fix it. Supreme Court can only do so much. And I think it's problematic when we just jump to this assumption that you go to court to fix it. Why do we go to court to fix it? Why can't we fix it before? So maybe a humble request, because Mr. De Silva is an advisor to the minister, is have the proper consultations. Let's see if we can fix this before it gets tabled in Parliament, because 2 weeks in Parliament is the only window a citizen has to challenge. And not everyone has the luxury to run to the Supreme Court. I mean, we are basic... Or the resources. Or possibly with multiple challenges, that may not be the main priority for some. So I think it's very important, to recognize, if we are talking about law reform that addresses the needs of the people, addresses the impunity in the system, and fix the system, let's do it properly. So that's a very basic, fundamental point. The other one is, I think, we look to the international saying, yes, the West, the Europeans, all of them, they have these standards. But, our own Human Rights Commission last year came up with the proposal that this could be brought within the penal code. Now, that conversation is missing. I mean, why don't we have these conversations? The Human Rights Commission also has a critical role in terms of the law reform process. These are all forgotten. Because why? A minister decides we need to push through something with no consultation whatsoever. So, I mean, maybe it's a question to ask is, has the Human Rights Commission been privy to this draft? Have they been asked for suggestions? Because yes, their name comes up in a few places, but is that the best way to do this? That's another one. Can I also ask, now we've gone through a previous draft before, the Counter-Terror Law 2018-2019. the then government agreed to certain amendments. When you look at this draft, this doesn't have all those recommendations. You know, they bring in, you mentioned the board of review. I don't think the board of review alone is going to solve the problem. That's within the executive arm. That's not going to be an effective check. We have an independent panel of review as well. Now, some will say, excellent, this is a new thing. But this is also something that came up in the 2018-2019 discussions. At that time, the conversation was, and that's an international best practice, to have experts looking at it and report to Parliament. So it takes away from the executive. Parliament is abreast of it and can question the executive arm. But the president appoints the independent review board. That's not going to really be an effective check because the president can appoint those loyal to him. So I think while we are at a moment of reform, let's really then go at proper reforms without putting plasters and say, but this is a bit better than PTA, so we should be happy. I think we should do much better than that. And then also look at what our own institutions have come up with. Why are we just going on the need for an anti-terror law, which I think many of us, I think Mr. U.R. De Silva will also say there are problems in the present draft.
Mr. De Silva, now the question of consultation or, you know, pre-drafting matters came into the discussion quite a lot. You yourself admitted that you need viewpoints from people, genuine people, you say, and I believe that the rest of the panelists in your view are genuine people, Mr. De Silva. Yes, exactly. Exactly. So has there been a consultative process? Are there reports from these consultative processes? I believe the 20th Amendment, when it was first proposed by the Government of Good Governance, there was an extended consultative process, there was a draft made, but it didn't make its way into Parliament. Has there been a consultative process for this particular piece of resolution?
In this particular matter also, there was a special committee appointed. They went through it. We don't know whether the Human Rights Commission been consulted or some other members have gone there and made their submissions or not. I don't know that.
You don't know.
But the fact remains that they have been people have been consulted and then they got some information, and because of that only this was prepared in a methodical way. I should say we will go through it very carefully, chapter by chapter. It improves. That is why now Babani says that something important where it has been considered as Section 50 anti-terrorism agency, where it covers a lot of people are there inside the anti-terrorism agency. They will go into these matters and do something. So that is why I say this particular legislator had considered and they identify that it should be improved and the fundamental rights should be looked after. But at the same time, Bhavani should know this is an act with regard to terrorism. Whether you like it or not, we should be, it is, as you said, preamble is very clearly stated, the protection of national security is very important. So for that, we can't do it with the penal code. We have to have a separate act. It has been identified in the other countries as well. So why are we worried about anti-terrorism or counter-terrorism or any other terrorism laws should be there? But if they are violating fundamental rights of a person, whether he is a terrorist or not, is a different matter. I am in agreement, you can't violate the fundamental right. To safeguard that, I should say, to safeguard that, this is the first time the magistrate and the Human Rights Commission and all these people can go and interview with it. And that is not whether with the other police officers, the magistrate is not going to ask anything. Even the confession, as she said, ASP's confession was there in the PTA.
It was admissible.
It was admissible. I personally challenged those confession during 88-89 series. We know how they drafted this and how they get the signature. So those things had been considered and it has been removed. Now the evidence should be there. No? People are not coming to give evidence in this particular situation like that. So for that purpose, it has been considered the confessions are important. But at the same time, the confessions given to the magistrate is admissible. That is also, magistrate should, for the sake of recording, he can't do that. He have to have a dialogue privately and ask whether he is ready to give it. And if it is given, it should be used as evidence against him. And then thereafter, he will remove the police officer, and only thereafter he will record the statement. So those things are good in terms of this act. That is why I say we have to consider. And the bail also. Mr. Hizbullah himself knows what happened to the bail application he has put forward. Now here, the magistrate had the power today. Sometime, if the magistrate is not satisfied the way that they are conducting the investigation, he is in a position to release him on bail. So that factor was not available earlier. The maximum period would be 12 months. And initially, only 3 months will be given to a detention order. So those things should be there. If a person is doing a terrorist act, you can't say within 24 hours you will be produced before the magistrate. In this particular also, he will be produced, but he will not enlarge on bail.
President's Counsel De Silva, I think you brought this conversation to a very important point. You said if a person is engaging in a terrorism-related act, you can't produce him before a magistrate in 24 hours. Exceptional circumstances do apply, and therefore extraordinary measures must be taken to protect the interest of the larger society. I'd like to pose this question to Attorney at Law Hijaz Hizbullah. Let's speak a bit about the offences. Let's take some time, because we spoke quite a lot in the first segment of this program regarding the procedures, how the procedures have improved. And while all the panelists, correct me if I'm wrong, in summation of what we've discussed so far, agree that there are certain lapses in the procedure, there are also certain positive steps that have been taken as opposed to the PTA. Whether or not there's a mismatch between the advantages and the disadvantages, that's an entire discussion. But let's focus our attention a little bit on the offences. So, Attorney at Law Hijaz Hizbullah, what do you think of the offences that have been listed under the Anti-Terrorism Act under Section 3?
As I stated earlier, and as Bhavani has stated as also, this is not what we call terrorism. And this is not what we understand to be a terrorism offence. And the main thing about anti-terror laws is not the offence, is not the offencers. And why the offencers and definition of offence is important is because once you get drawn into that set of offencers, you are subject to a completely different procedure. That's the point.
This extraordinary procedure that we were speaking about.
For example, a suspect for murder under the penal code is dealt with completely differently to a suspect for murder who's also brought in under the PTA or to the anti-terrorism bill.
If I may interrupt for a small thing,
Yes.
the 12 months period is the mandatory requirement for a murder in penal code also. They can go up to 24 months. If the Attorney Generals go to the High Court and get an order, he can be there for 24 months. Here, of course, 1 year, as quite correctly pointed out, this act also says 12 months. So same thing, murder.
So
Procedure.
So the procedure is entirely the 12 months he's entitled to ask for bail. He's entitled to apply for bail, right? Very importantly, the person who's charged for murder under the under the penal code is produced before a magistrate, and at that point the police has to show has to produce a B report setting out what have we found against this individual, what is the evidence against him, and why we suspect him for murder. And that gives the magistrate an opportunity to examine that and to make a decision as to whether this person should be further remanded, etc., etc. So there is that. From the very word go, he's engaging with the judicial system and is able to make his position known and safeguard himself. But the same person or another person for the same set of facts, but who's drawn into this terrorism law, goes before the magistrate, but he does not get those protection because the magistrate's hands are tied because there's a DO. There's a DO against him. And then at the end of the 3 months, the DO gets extended further with a confidentiality report or a confidential report. right? Which there are lots of issues. That's a very dangerous introduction into the Sri Lankan legal system about these confidential reports, where it's not an open, transparent decision-making process. For the first time, we have these confidential reports coming.
Do we
in.
have it right now?
We don't have
We don't have it in the
now
system
I'll just
on
explain that
confidential.
history.
Quite right,
Yeah.
pointed out. In 1954, there was a decided case. On that basis, they put forward all these secret reports. But with Mahanama Tilakaratne's case, it is clearly stated there is no such confidential report. All reports filed in open court are benefited to other people
Will
also.
No, why I'm concerned about this confidential report is because in my case, the magistrate, Mr. Ranga Disanayaka, was insistent on the fact that the evidence against me or the progress of the investigation, as Mr. U.R.D. Silva knows, you have to report progress of investigation. But for a terrorism case, you don't do that. You don't show progress of investigation. But Mr. Ranga Disanayaka insisted that they must show progress of investigation. They must show what are they doing with this person for so long. What have you found against him, and what are you investigating, and why do you need to keep him for so long? So these are the questions he was asking them. And at a particular point, the Attorney General's Department took up the position that they do not need to file B reports like in the normal law, like under the Criminal Procedure Code. And Justice Ranga and Magistrate Ranga Disanayaka made an order saying that there is no such thing as confidential reports. There's no such thing as keeping certain things away and just showing certain things to the court. That everything must be shown to court. So this is also a very dangerous introduction. So going back to your question, Shalan, about the offences, so the danger is that, so the moment you broaden the definition of offences, where you are able to catch a large number of people, although you call this terrorism, but actually it is not. Actually, to be very frank, I feel that this act is targeting a much broader group of people.
Attorney at Law Hizbullah, just if I could read these offences for the benefit of the general public, because I think the offences have been set out in quite plain English language in this act, as opposed to many of the other legislative enactments, including the Penal Code of Sri Lanka. The acts of terrorism that have been defined under the act are intimidating the public or a section of the public. Now, this is, of course, for our viewers to decide and think a little bit about this and see if, in your mind or in your understanding of this word terrorism that we discuss here on Face the Nation and the discussions that have been going on in the legal sphere, out of that, do you think these offences are terrorist-related offences? So I'll read the offences to you and then we will put it to the panel and discuss further. Firstly, intimidating public or a section of the public. Secondly, wrongful or unlawfully compelling the government of Sri Lanka or any other government of an international organization to do or to abstain from doing a certain act. Compelling the government are wrongfully and unlawfully. Those are the two words that have been used to describe the acts compelling the government of Sri Lanka to abstain from doing any act. Thirdly, unlawfully preventing any such government from functioning. Preventing the government from functioning is an offence that has been described as terrorism. Violating territorial integrity or infringement of sovereignty of Sri Lanka or any other sovereign country. Fifthly, propagating war or advocate national, racial or religious hatred that constitutes incitement to discrimination, hostility or violence. So that's a little bit for the general public to think as to if or not these are acts of terrorism. So let's go one by one. Let's start off with the first one, intimidating public or a section of the public. Attorney at Law Hijaz Hizbullah, what do you think?
Again, this could, actually, Shalan, the offence of terrorism is much wider than is it, because there's section 1.
There is also abatement and the companion offences.
Yes. Now, if you look at intimidating public or section of the public, it also includes section 483 Penal Code, criminal intimidation. The offence of criminal intimidation is I would say similar to what is being said in 3(1)(a), which then raises a question: why are we having this law? For what? The offence.
May I interject there?
Yeah.
I think the way to read this is to think of intentions and acts.
Acts, yes.
Right?
Actus
What
reus
you-
and mens rea, the basic
No, but
components
what
of
you
it.
just read
Okay.
were the intentions. So just the intentions alone don't constitute the offense.
Offence.
You have to have the act alongside the intention in order for it to be completed as
You mean
the
murder,
offense.
grievous hurt,
Correct.
hostage taking.
So if you commit murder with one of those 5 intentions, it becomes the offense of terrorism. And what I think Hijaz spoke about earlier is to go down that list of acts. For example, disrupting or obstructing an essential service. That's in F. And then you go to L, being a member of an unlawful assembly. Those are acts that if you have a certain intention in doing those acts, like compelling a government to do something or abstain from doing something, or disrupting the functioning of a government,
Right.
together that becomes terrorism. So essentially, any strike action will fall within that definition, because a strike action will invariably obstruct essential services. If, for example, if medical professionals go on strike, that will be a serious obstruction to essential services.
And it will prevent the government from functioning.
And
Precisely.
Yeah, and just Gihan, okay, that's if they do it. But even preparatory work, even if you're preparing to do it,
That's right. Yeah.
you can be brought in. So there is a meeting, and as Bafani said, you could be having a meeting discussing there is a salary problem, or there is a gas problem, or there's a fertilizer problem, and what shall we do? Why not we go on the road and have a protest? Preparation to commit an act of terrorism. You can be brought under this. And you can be given a detention order where you will go before a magistrate. Magistrate will have no power, nothing to do anything to you. And you will stay inside for 3 months. But that will be the end of your civil activism. That will be the end of that trade union. That will be the end of that farmer association, where the members get locked up for 3 months. And that is the amount of intimidation that a citizen is now facing when they are faced with a law like this.
Mr. De Silva, how do you
I don't think it is correct. If you are talking about this particular act and say 3 months they have to be in remand, I don't know how we can say about magistrate remanding the person merely. The police report says that under section 14 you have to remand this person. Just because of that they remand the person. It is happening.
No,
but it
President
is not the
De Silva,
law. It is not the law.
What we're discussing really is the offense. So if a person has not really committed an act of terrorism, or what is globally accepted, or what is generally understood as an act of terrorism, there is no reason for that person to spend a night in prison.
No, I
let
don't
alone
think it is
3
correct.
months in
Yes,
prison.
I am certainly in agreement with you. But the
what
fact
is
remains.
so because in Sri Lanka, I think a lot of the skepticism that is there in society, or why we have so many organizations, civil society, and different individuals criticizing the act or the offences that have been mentioned in the Anti-Terrorism Act, is because of past experiences. Because to my knowledge, I have never heard of a case where there is a terrorist out on the loose in Sri Lanka and there haven't been enough laws to prosecute the terrorist. There have always been an ample amount of laws to prosecute this terrorist, if at all they hadn't been used, which was the case in the case of the Easter Sunday attacks or the attacks in Digana. Some of those people may be still out in the open. Laws have still not been enforced against them. So in the past, what has happened is that the broad definitions that have been given in these acts have been abused to arrest people, to detain them. We have an example on our show today as well. There was even an instance where a woman who was wearing a dress that had the picture of a steering wheel of a ship on it, and she was arrested, saying that under the ICCPR Act, the different act, but the concept is pretty much the same. So we are here living in a country where there has been ample abuse of open-ended laws, and never, to very little instances, or at least not to my knowledge, where there have not been enough laws to prosecute terrorists. So, President's Counsel De Silva, do you not believe that there should be better safeguards when it comes to defining these acts of terrorism, because they have been abused, or the provisions have been abused for so long? That's why the people are scared, that's why they're worried. So wouldn't proper provisions to frame these laws properly, saying these are the acts that are acts of terrorism, wouldn't that instill a certain amount of trust in the people?
Charlotte, you have to read these particular clauses together, as he quite
Right, exactly.
Section 2, 3 and 4,
Okay.
together only
Understood.
you can come to some sort of conclusion. What are the terrorists?
So let's take the example that was brought about here. Let's take the example that was brought, a farmers organization getting together, discussing a strike action. At the discussion stage, they can be arrested. If they stage the strike action, they can be arrested. If they go tell their family members about it, and
But that's not correct.
that's not correct.
If
that's
they,
not an
if the
offense.
police are going to abuse, they don't have to discuss even. They can be sleeping and they will be taken up and then
Which happened? Which happened?
What happened to him?
So what's
You can't blame
Now
the
that's the
act
point.
because of that.
No, that's the point.
Anyway happens.
That's the point. Now that happens. Now in a country that
That happens,
we put
certainly.
this in law. That's
And we
that's-
normalize it.
You're
accept
entrenching some very problematic systems and practices, but also thinking
Yeah.
that they feel they can do it, and that's
That
the
is what
norm.
is happening. But we are concentrating on this particular act. But if you are talking about the way that the police are handling these matters and abusing this law, I am 100%. I can give thousands of examples for that. Now, but if they want to take a person and remand, they just go. And the Supreme Court has clearly stated, merely to satisfy the police version, you must not act you must act methodically, not like a rubber stamp.
Judicially, you must act judicially.
Judicially.
Now that's
so
the
it
point.
is there. It
Now
is there clearly.
Does
stated.
the magistrate have that power now in the DO? No.
My submission would be that it is there. The magistrate, for the sake of remanding in earlier cases, he doesn't have to do that in this particular incident. If he has the material with him and the detention order does not carry the material point, as he quite correctly pointed out, I am totally against this so-called report. Now, Rahas, confidential Rahas report, there is no such report. And the laughing part would be that the particular report will be submitted to magistrate, and at the same time it is clearly stated the lawyer concerned appearing on behalf of the suspect can make submission. On what basis? Without seeing the confidential report, how can we make submission? It should be available to the people to get some idea whether they are coming out with the exact. That is what his particular judge has clearly said. Now he has specifically ordered to come out with that report. To safeguard their version, they have included Rahas report. If they agree with that, they can file a report to say this is what the evidence available against Hizbullah. So that then the magistrate is satisfied. No.
So let's take a common contention in the general public now. One of the other fears that has been coming out a lot is that this law is being brought to suppress trade unions. And
No,
President's
if you-
Counsel, you are
on the
disillusioned.
face of it, you can say like that. That is, you are
No.
making the point.
I'm not making
on
the point.
view of the
No, no, no. Trade unionists are saying this.
If they are properly considered and if they have in some sort of criticizing the government, if they come out with in proper way, it should be recognized. Otherwise, merely because if they do that, if the police are going to take them into custody, it's wrong. But they will do it. Certainly, they will do it because they will they connive of this act and they will do it. That is the implementing part. So, if they without this particular clauses are there, they will do it.
They will
Can I-
somehow
can I
do it
just-
as
can I
even
just say-
during the COVID, during the pandemic, they used the quarantine laws
That's right.
to suppress the trade unions. Didn't the government use the quarantine laws?
When the PTA was introduced, Mr. Devanayagam was the minister who introduced the bill. And if you read his speech, he speaks specifically about acts of terrorism or certain acts of violence that was happening in the country. He mentions particular organizations. He mentions particular incidents, and then he says, I am producing this bill to deal with that. Now the question is, to whom is this being addressed to? Right? So which forest are we going to clear with this chainsaw? Right? That's the question. That's the question. So if it's a hypothetical or conjecture or someone with imaginary forest, then on whom will this chainsaw be used on? That's the point.
Shalan, I'd like to bring in the area of social media and media and the effect that this bill could have on it. Can we have Bhavani's views on this?
Yeah, I mean, I mentioned this before. If this law passes as it stands, Clause 10 is extremely dangerous. If you look at it, it's not just mainstream TV, it's online, it's internet, it's everything. So it's basically the whole freedom of expression, freedom of publication, that is going to be held hostage. And Clause 11 follows from that as well. So those two, in a sense, in terms of media. But not just that. I think, it's a very important discussion about detention, magistrates, all of that. We forget a very significant component of this bill, which is the powers of the executive. One is the prescription orders. That's for 1 year. A media entity, a civil society organization, a trade union, a law firm, any entity can be prescribed for 1 year by the president on reasonable grounds. Now, when you have so many clauses that could be used to target for someone for holding a different opinion, a different perspective, it seems people have different notions of what terrorism is. I think even around this table. Now, Shalan, you mentioned about Digana. I would beg to differ. I think that there is a component of ethno-religious violence. Do you classify that as terrorism? What's the threshold you use? Those are things we need to be very careful about in a country such as Sri Lanka. And I go back to Digana because you kept using it. Digana, Aludgama, all of that, if you look at it, was a very particular tool by the majority community to target a particular minority community.
So that's not terrorism.
That's ethno-religious violence targeting minorities. Who was arrested? Who wasn't arrested? I mean, we've had this conversation in this show itself. And I think it's very worrying when you bring those dimensions into this anti-terrorism law, when we have other laws in Sri Lanka that can deal with it. So do you clump everything into this? That's one dimension. If you have the conversation critiquing those things, you could fall into clause 10, 11, possibly because the president might have reasonable grounds to fear there might be a terrorist activity, there might be a prescription order. So organization, not just media entities, organizations that may have a different view could come under this. And that's very worrying because it shuts down a very fundamental right, which the Supreme Court has said, freedom of expression not just should be tolerated, it needs to be encouraged. Dissent is a fundamental right that we take for granted in a way. So your point, Niresh, is that there are things in this, in different places, that if we miss at this critical moment, could have such a worrying impact. Because let's be very realistic. PTA, a temporary law, it still has the word temporary. 44 years later, this could be passed very quickly. And how long are we going to be stuck with this? With very broad definitions. So these token efforts of saying this is something good, this is an improvement, let's go to the Supreme Court, all that is there. But we are working in a system that we have, even within this room, we have different concepts of what terrorism is, what due process safeguards are. You know, so it's a very, very, very critical time where we pause a bit. My point is we pause and have that conversation and improve whatever we can, but really critique what's there in terms of the executive powers. The fact that there's very limited checks and balances. It says you can challenge a prescription order, sure, but 1 year, what does that do to an organization? Where is the due process? And then someone might say, but that's a terrorist organization. What's stopping you from calling someone a terrorist? And I'll also bring this example. Tissanayaga, a journalist who was convicted under the PTA. Lots of issues in terms of that process. He wrote a piece, an article, a magazine on what was happening in the east of Sri Lanka about the violations. On that premise, he was convicted under the PTA for having his opinion. He was a journalist. He did his work. Now, under this, not just him, anyone else who has a different opinion could be classified as a terrorist. So that's the danger we are facing. We can talk about, yes, it's providing these little things, but overall, the overall scheme of things, and Mr. De Silva, the point is, we have an opportunity to fix this. That's my point. We can't rush it.
So would you say we need more stakeholder engagement and transparently so, where such a law is not just thrust upon us?
So, I mean, Niresh, the point is, I know Gihan is trying to come in here, but one very basic point. We saw in the media committee giving the report to the Justice Minister. Now, as far as I know, that committee never had consultation. Say the committee was a technical committee, but now it's with the Minister. It's with the Minister. It's being gazetted. Why can't the Minister have consultations? Why can't it go widely across Sri Lanka, use the media, use channels like this, forums like this to have the conversation as to what do people understand in terms of terrorism? What are the safeguards needed? Why do we need this law? In the context of the Easter Sunday attack, what are the critical needs of Sri Lanka? You know, I mean, so I think these are very valid conversations when we are trying to ram through something so massive. Because that luxury wasn't there with the PT, and now we see how it's being abused. Let's not repeat those mistakes.
Also, we'll provide some space for some questions from the general public, and this one, of course, is directed to President's Counsel UR De Silva. It goes like this. There is no social contract. This government is clearly not the one that the people wanted. I believe referring to the mandate that was given, especially to the President, who was not voted into Parliament, or to the position of presidency. This was much clear to the whole world. Mr. Wickremesinghe became president as a direct result of this. What the people asked for was an opportunity to vote for a government of their choice. Now that dream or hope has been kidnapped by the man who didn't even win his own seat in Parliament. The very principle of democratic philosophy has been ignored. In these circumstances, can this piece of legislation sustain itself? And can he use this appointment to usurp the people's freedom?
If he wants, he can use it. It's a simple word. So we are predicting those things. So why he should come out with that? Without this also he can do, if he wants. So people will come and say, you did this and that. So now the same person has stated that his appointment is wrong. It is not correct. 1978 Constitution very clearly states Parliament has the power to appoint their president. So by doing that, they have appointed Ranil Wickremesinghe. So whether he is going to allow the people to come out to streets and do whatever they want. If they want to sabotage the government property or they destroy the government property, if they are allowing them to do that, certainly what I am saying is the law is very clear.
So Mr. De Silva, now if your submission is that the president can stop the people from doing whatever he wants, if he wants to, even without the Anti-Terrorism Act.
That is what I see.
Okay, if that is your position, then why have this act? Why can't
he doesn't
the
want to do
president?
that.
Why can't the president use that power that you say he already has to apprehend terrorists?
No, he is not going to do it without any provisions of the passed by the parliament. That is his integrity is there. He wants the parliament to come out with this legislation.
So I'll pose this.
If they are not ready to pass this, then that's the end of the matter. What he wants to do is, he wants to take up this matter as well as anti-corruption law. Those two areas he is concerned about. He specifically stated, I want the law to be there, and a person who is violating, I will not tolerate. So how he is going to do? He wants to have this particular legislative, and then only he will consider whether they are sabotaging the work and they are not allowing the government to give the maximum benefit to the people. So that is what they are concerned. Anyhow, now anti-corruption law is also there. This particular law is also there.
They are still there.
And that's what I'm telling you. So those matters, of course, we have to discuss. As Bhavani stated, that this is with regard to media. I don't think for the sake of passing this, you have to do it. The repercussions are very important, and what we have to consider is whether we are going to pass this for the sake of asking, because these are very important areas to discuss and come to certain understanding. I am not in agreement with the way that they are handling the media thing, but we are not in a position to allow the media to do whatever they want. Social media, what they are doing, and you see that some social media people, they ask to come and join to destroy the parliament. So whether we are going to allow those things, they are terrorists. What I am saying is, at the moment we can't take them into custody because there is no such provision. Here, of course, if they are doing so,
I think Dr. Gehan has.
I think that I can't agree with Mr. De Silva. I think the current Prevention of Terrorism Act is so broad that
offences against public property. They can be used under that law.
Under abatement.
No, only thing is that they are asking them to join.
So asking them to join is also
incitement.
You can't interpret it that way. That is why they still not in custody. So what I am saying is,
but President's Counsel De Silva, people were arrested. I think Anuruddha Bandara was arrested for #GotaGoGama.
I think the reason why that was that those arrests were not done was because at that time Aragale was a good thing. And that's the problem, and that's also important.
That's a really important thing to unpack a little bit. Why do we distrust this process so much? And then you have to go back to the PTA. PTA has been around for 44 years. It's titled the Prevention of Terrorism Act, and if that's the objective of the act, it has failed spectacularly. 44 years, it has presided over more terrorism than we can imagine, right? So it has failed. And you are onto something when you said that Digana didn't fall within this act. Yes, terrorism may have a particular definition in our heads, but the PTA doesn't actually provide that definition. And if you look at section 21H, which is used against so many people, including Hijaz, including Tissanagam, that offense is an offense about communal disharmony, racial, religious disharmony. So, absolutely, that offense can be used to prosecute people who instigated violence against the Muslim community in Anutgama, instigated violence in Gintota, instigated violence in Digana Teldeniya, and then subsequently in Gampaha and Kurunag. You can use that offense. But the reason we distrust the PTA is because of its selective use. It is not used against those from that community, the majority community, when it's inconvenient politically. It's become a political, used against those who are from minority communities. The Tamil community bore the brunt, then the student community in the late 80s, Mr. De Silva himself talked about those cases, then the Muslim community in the aftermath of Easter Sunday, and now once again the student community from the singular community in the context of Aragali. It's always used against communities that the state considers to be problems, not against those who are politically aligned to the state. That is the problem with the PTA, and the PTA is a child of a particular form of authoritarianism that we were used to for the last 40 years. Now there's a shift away from that form of authoritarianism to a new form. And that new form is far more sophisticated, far more insidious. It's not going to kill and disappear you, it will jail you under the law. It won't burn down your media houses, it will take over the media house. It won't murder voters and electors, it will manipulate them. So this new form of authoritarianism can't have the PTA. It has to have a more sophisticated law. And the ATA is a reflection, is a child of this new form. And that is what we need to try to understand about what is going on in terms of the politics. The ATA is a representation of the new, sophisticated, insidious form of authoritarianism that is taking over the country.
So, President's Counsel, UR De Silva, since you're the representative, of course, from the Ministry of Justice that drafted this legislation, I'd pose these questions to you. Of course, we need to understand the backdrop in which this legislation is coming into Sri Lanka, because the preamble states that there is a huge threat of terrorism, but the last recorded, or at least the last act of terrorism that everybody agrees here and in the country that was an act of terrorism is the April 21st attack, and that was back in 2019. And it is the general understanding of everyone here that there were enough laws in Sri Lanka to apprehend Zaharan Hashim, to apprehend his accomplices under the PTA at the time and prevent that mass massacre from taking place on the holy day of Easter Sunday. So against such a backdrop, I pose this question to you, given the current situation in the country. So the question is, are the corrupt politicians who destroy our country every day the real terrorists? Haven't they done enough to our people and our state? But they are scot-free today. The acts are being brought in to cage the people's freedoms instead. Are not corrupt politicians across all sides, devoid of party politics, the real terrorists in Sri Lanka?
Yes, perfectly right. The people who have destroyed our economy, the corrupt politicians, are the real terrorists. That's correct. So now what we are going to do is we are producing a new act, anti-corruption act, to deal with them. So that's a separate thing. We have to discuss later on that.
Definitely, we will provide space on Face the Nation.
We are concerned about the Terrorism Act, where we say these people also can be considered as terrorists, but they have already done it. Now we are concentrating on the future thing. We can't go back. So what we are saying is we are concentrating on these people. As you said, the PTA was there when the Easter attack bomb was there, had happened, but the police have not acted upon. That is the very reason I am telling you this was happened, because PTA was there. There were reports, and then there were reports to apprehend these people, but unfortunately they haven't done it. That's a separate thing. But that's why I always say implementing part is different from the legislature. So it is very clearly stated in that act also, but what I'm saying is they have come to some improvement. Some improvement. I am using that word. This is not a perfect piece of legislation, but as they say, we have to concentrate on those areas also to improve this.
Now, President's Counsel UR De Silva, you agreed with the viewpoint of our viewer saying that corrupt politicians are also real terrorists,
yes,
or the real terrorists here in Sri Lanka. So, it's only reasonable to imply that Parliament consists of a certain section of these corrupt politicians, because there are career politicians there are various politicians who, judging by the events that ensued Sri Lanka during the past few years, just a few years, of course many might even not remember the times when we had 15-hour power cuts or had to stand in line for days to get fuel, but when we start speaking about it, it comes back into the limelight. But so the current situation or the state of affairs in Sri Lanka is that these politicians, these corrupt politicians, let me add that adjective because not all politicians are corrupt, but these corrupt politicians who are in Parliament, a few, are also going to be the ones who are going to vote in favor or not of this anti-terrorism bill.
Yes, correct. Yeah.
Is that all right with you?
No, it is not. what can we do? So
we can go for an election.
Election. There is now you can do that. That's okay because now time
President
period is
Council,
over.
Silva, so given the situation in the country, really, that people distrust this parliament, I don't think anyone can really object to that. And then the people made it very well known after the events of last year, especially July 9th, I believe. So against such a backdrop, don't you think that since we are looking at the future, the president is saying Sri Lanka is going to be a developed country by the year 2048. Looking at the future, isn't it really better to have a law that will stay? Because the opposition is against this law. Many of the civil society are against this law. So what's to stop whatever that government that comes in from repealing this law completely? Because we're not looking into the future enough. Wouldn't it have more of a public endorsement if there is an election? A general election can be called. There is already a local government election, and then you can use the local government election, of course, to get a sense of where the people stand or where the public mandate stands. But why are all of these measures of understanding what the people really think about these and think about the actions of the government being pushed aside completely, and then this act is going to be pushed through Parliament?
You see, we can't wait till the election comes and pass this particular legislation because the foreign countries. So when we go to the foreign countries, and then when we go there and make our presentation, they ask these things: what have you done to this PTA, and what are the steps you have taken? So we have to have that particular. Let's say that's a department. The next government, if they wish, they can do whatever they were. But the fact remains: do you believe that when the election comes, separate people will come and do the better thing? No, the same people with different codes come and do the same corrupt things. That is a fact.
I think at least on this matter.
That is why, wait. That is why I specifically informed the Aragale people, please come forward and use this political situation and then form a political party and then come to the power and do the needful without going to the streets. I told them, but they haven't done it. They just asking various things, that's all. But the fact remains, these same politicians, when the elections are there, they will go to separate places and they will contest the same thing. But the local government election, merely because they are there, you mean that we can get a sense? What happened in 2019? The sense was that this port tour was doing 47 or 57%.
Yes.
But so what happened then?
So, President Council, you are De Silva, don't you think that's for the people to decide? Because at the end of the day,
people
we're a
can
democracy.
decide. I am in agreement. But with this election system, people can't do that. Because the same people will come and then now when this bill is arguing or before the parliament, you watch the parliament proceeding. Last time the previous government brought this PTA amendments. What happened? Nobody was talking. All they say, we are against, that's all. They have not come out with proper argument or proper suggestions to this, and even they don't know as Bhavani said, the confessions they are still in the PTA Act.
So, President Council, you are De Silva, the Parliament is still the same. Parliament is still the same. So you believe that an act that comes through Parliament now would be better than,
No, better than waiting for some time, because we don't know what will happen, whether the parliament election comes or the president will himself thinks that presidential elections would be there first. We don't know that.
So this is a classic case of that Sinhala saying, "Mag hitiyot tonasi, gedara giyot tamunasi."
That's correct. Yeah, that will happen to us. 225 people. What they are doing, I don't know. What
I think Niresh is.
I think Bhavani was trying to make a point.
I just want to, on the whole issue of elections, I think we need to recognize, and this is diverting from the bill, but local government elections should have happened now.
we have the
money to
well,
spend
you know,
on
I
it,
mean,
they can have it.
the money was
coming from the advisor to
allocated
the
last
Ministry of
year.
Justice.
I know the problem
glad
is
to
the
hear
money.
that.
That's glad to hear.
Yeah, that's right.
So-
I mean,
so
you can
I-
expect a headline tomorrow saying,
So
advisor to the
basically,
Ministry of
Mr. De
Justice
Silva
confirms
now
election.
will have the
No,
elections,
as
is
you
it?
said, it is important. My personal view is local government election will not do anything, but we have to have elections.
But President's
It's
Council, De Silva, do you
franchise,
think
you know?
it will come about now that we have money? We have money, it will come about now?
Now we have money to spend for elections, but not for local government. But I will say that the parliament election or the presidential election, so same money can be used for that. So, but I am saying that these are things that we are in our control.
Right,
but
exactly.
What I am saying is, without having
Based on
local
information
government
available to you.
yeah, without having local government election, even if we have sufficient money to go proceed, we must have a parliament election, because people are talking about that this is not a proper parliament procedure. So that is why we have to have. But the fact remains, the president has the power to have the parliament election or to go to a president election later. He has to decide. We can't dictate terms.
So can I, on that issue, now I think we are in agreement, elections should happen, people should be able to choose, there should be a
Yes,
fresh
correct, yeah.
mandate. We agree on that. So, I mean, when we are having this conversation, when people are extremely unhappy, there are protests, you know, daily, we agree or not, there are protests happening. People are calling for a change. They are disappointed. You know, they're saying they're not representing. Why is this kind of bill then trying to be rammed through when clearly, I think we all agree, elections then should happen, and people who let people select their representatives, then who can go and do the lawmaking for them. I mean, that's a very basic thing. No? So why is the government so keen on rushing through this? And as you mentioned, the anti-corruption bill as well. And something you also mentioned, the government has to go and tell the international community what they're doing. But maybe let's start with they should be telling the citizens what they're doing. Why is that being missed here? I mean, the international community, yes, they've been assisting us in this crisis, they're critical, but aren't the citizens more important? So,
No, Bhavani. Now they are asking, why are you not having these changes? The anti-terrorism, PTA, those people are asking various questions about, and this corruption also. Lot of corruption are there in Sri Lankan society. So why are you not taking action? So we will look after the election. We can't go and say that, because we have to deal with them till the elections are there. So till such time we'll do that. And if the new government coming into power is not satisfied with the suggestion taken by you and then others also, if they are ready to listen to yours and for me as well, and then they can have a separate piece of legislation. There is no harm for that. At the moment, we have to have this particular thing, because you know that we have to go before the international community and say we have done some sort of arrangement or the changes. These are the changes. Sometimes some people may not like it. They will come out with various suggestions, but you can't expect everything to be done by the government in the way that you want. But if you are satisfied to some extent, if there are say areas to be increased or to go forward, we will do it. But at the moment, this had been looked after very well. It has considered various chapters, and each chapter comes out with various areas, and it gives more power to magistrates, judiciary, the high court judges and the AGs, and then there is this review board also, and finally anti-terrorism agency also, they have been considered. Those are the important things what I say, and we will, if we are ready to adhere to that, we will go. But I am not 100% satisfied with the particular legislation, and as they say, we have to improve this. That's what I want to say.
But Bhavani, does this act has any effect on the upcoming elections to come?
in terms of which elections?
Any election. Is there,
So-
because now, according to this act, the president can prescribe any political party, not just an organization, a political party. So is there an effect on the election, and is this the urgency the government has to
And
bring this
also on
before
the
the
same
election?
lines, if you want to organize a political rally and you do it over Facebook or whatever, isn't that also subject to this act?
And unlike before, where you need a directive of the magistrate to stop a rally, but here now a police officer, the rank of SS, senior superintendent of police, can issue a directive to stop a rally, a public rally.
Exactly. This is my worry, that while we say, yes, let's wait for another moment to get laws passed, why are we settling for something that provides such broad powers for particular entities with very limited checks? And what is this terrorism? In terms of, if you have a discussion which is critical of the powers of the day, you could be considered falling within some of these categories. Who decides? On reasonable grounds, the president can prescribe reasonable grounds.
Reasonable to whom?
That's my point. It's such a broad power. Yes, it provides for the Court of Appeal, that is there, but I think we all agree court proceedings also take a long time. What happens then in the interim?
I think a long time is an understatement.
Long time is an understatement, but that's the reality. So I think your point about not just elections, it's about dissent. It's about holding a different opinion. Now, last year, many of us were part of the citizen mobilization, the Aragalaya. People embraced this.
Even President Vikramasinghe was a part of the Aragalaya.
Well,
He supported it.
He gained from it. He gained from it. But when it suits people, they can turn that narrative around. Who decides then what is a good Aragalaya, what is a bad Aragalaya? I mean, these are narratives that can be easily construed, and if you have such a broad law, you could be classified as a terrorism. But can I also say something that we seems to have missed here? This law is so broad that it's trying to bring so many things the government has also attempted in previous ways. This has rehabilitation, this has the president's powers to issue regulations. Now, there are cases before the Supreme Court where the Supreme Court has given a stay order on regulations under the PTA issued in 2021 on the whole area of rehabilitation. There is a stay order. Last year, the government tried to bring the rehabilitation authority. I mean, it's now the law. But if you looked at the bill, it was so broad. One had to go to the Supreme Court to make it narrower. Now, those things have been attempted. One matter is still before court, and this bill brings in the rehabilitation dimension, but also the powers of the president to issue regulations. Very broad.
You are not satisfied with the rehabilitation process?
I'm in court on this issue. This is something very worrying, Mr. De Silva, and I think we can have a conversation. What does rehabilitation mean? Who decides rehabilitation? Rehabilitation now in Sri Lanka is used as a punishment, as a targeting tool, and that's the problem in Sri Lanka. We use these laws, just give me a second. We use these laws to go after individuals, target individuals, and that's a conversation we need to have. But can I also quickly bring this? The fact that there is also a power for the president through the sanction of the High Court to issue prohibited, indicate what is a prohibited place. Last year, the government tried to bring high security zones under the Official Secrets Act. Now, that was stopped because people protested. People pushed back. People went to the streets. If this law passes, we can't do that. That will be possibly considered terrorism. So, what we did last year, just a matter of months ago, may be classified as terrorism. And then what do we do then? Do we sit back and say, oh, well, but that's the law now? No. So that's my whole premise is, why are we ramming through something that is so broad, give such broad powers to the executive arm and actors within the executive arm with very limited token measures on the other.
Dr. Gehan Gunathilaka, just one more question from one of our viewers. So, this whole conundrum that Sri Lankans find themselves in right now, with the parliament having lost mandate, what happened last year, the economic crisis that we're in right now, it's very confusing. So, the question to you is, of course, to try to bring in concepts of constitutionalism, democracy, all of that, and try to explain to the public the answer to this question. So we're asking some of the most corrupt politicians who belong to a parliament that has lost the trust of the people to vote for an anti-corruption act that won't capture corruptions of politicians in the past, and an anti-terrorism act that will suppress any form of dissent among the public. How do you really wrap your head around this particular unfolding that's taking place in Sri Lanka right now?
Yeah, I think that's a great question, because it is a very, very strange time to be bringing a new anti-terrorism act, because it's a time in which the people have taken to the streets, have been questioning the legitimacy of a government, have been dissenting, and then at that very moment you have a new law that can potentially criminalize those very acts. So people are right to question the timing of this particular law. People are right to question the opportunism, the political opportunism behind this law. And that goes back to the point I was making. This is the new face of authoritarianism in this country. It's not a surprise that this law comes at this particular moment, because we are making this transition. And what is perhaps scary and really something that we need to think about is that a lot of people will prefer that form of authoritarianism, and the government is banking on that. That is why they are bringing this law. People in government are taking this chance because there is a gambit here that people will support this form of authoritarianism over the previous form that had a lot of bloodshed, a lot of acute violence compared to a more insidious form. So that is why we're seeing this law, and that is why if we want to resist authoritarianism in all its forms, you have to resist anti-terror legislation in all its forms. Whether it's a clumsy, sort of draconian piece of legislation like the PTA, or a sophisticated, insidious piece of legislation like the AT. It just boils down to whether we have an appetite for authoritarianism, and if we are a democracy, I would say, I hope not.
So, President's Counsel U.R. De Silva, there is this concept in at least law that we learn. It's better to let 100 guilty people go free than to convict one person who is innocent. Now, we as Sri Lankans have really done our country wrong, or done our countrymen wrong, when we passed anti-terror laws that didn't protect their rights. And I think, again, I turn to Attorney at Law Hijaz Hizbullah, who has suffered at the hands of these faulty anti-terror laws. Now, President's Counsel U.R. De Silva, you yourself admitted that this is not a perfect law, and I'm not saying that we need a perfect law, but there are substantial gaps in this law, which you also admitted. You said there should be a consultative process where this should be put through, and where a better piece of legislation should be brought out. So again, why has this been gazetted, at least, with so many faults in it, according to the same, based on your own?
You can't see a perfect legislator coming in particular way.
Right.
You can criticize at any moment, even if you think that it is perfect. Some people say it is not perfect. So that is how it comes. You can criticize that. The way that you are criticizing is the important factor. Whether you are for the sake of criticizing is the issue here. Now, what I am saying is, earlier PT Act was there for a long time, and they say that it was a draconian law, and then they say the people can't retain a lawyer or get the services of a lawyer. They can't consult their family members, and detention orders are given for 18 months. Long things were there. Confessions were admitted. So those things are not there in this particular registration. So is that an improvement? So people who are talking about in the negative way, they don't like to say these things. They say though there are so few things are there, but the main thing is that our people who are going to street will be taken into. They can't do in that such a way. If there is the things that are there mentioned, as you quite correctly pointed out to the people, that they have been done, if they are doing murder, grievous search, hostage taking, abduction, kidnapping, likewise there are a lot of things that have been there. But merely because that are there, that does not mean that police can take them into custody for the sake of taking them into custody. They have the material. As Mr. Isabullah quite correctly pointed out, when they produce the detention order, they should come out with the evidence available against that person. If that is not there, then the magistrate can query of that for 3 months period. They are talking about a lot of things about 3 months period. 3 months period, how they should be kept on, it is clearly stated. They can't just go there and keep a person in a place where the people doesn't like to be there. They don't like. If they don't like, they can say this is what is happening inside the detention place, and we are not satisfied. They can inform the magistrate. That particular section is there. What more you want? Now earlier they say that the president issued this detention order with regard to university student. You can remember that he is a politician. How can he?
So President's Counsel, you are De Silva. Now we're talking a lot about justice and learning from past mistakes.
That's
you
right.
yourself said that,
Especially with regard to
yes, exactly, the incidents.
the
that happened
report is also with regard to his detention.
Exactly.
Because that is why they come out with the report.
So President's Counsel, you are De Silva. Now, for a person,
But even I was not consulted.
Just to be clear.
Just to be clear.
so for
There's a
a
report on you without you being consulted.
It's a confidential report.
Case report has been consulted.
So
Gone through.
for a person like Attorney at Law Hijaz Hizbullah, who has suffered so much under the PTA, I mean, maybe some things that the general public don't really know. He missed the birth of one of his children. He missed a birth. He was kept away from that child for over a year. He was kept away from his family for over a year, just as President's Counsel Yuvar De Silva said, those draconian provisions. So for a person like Hijaz Hizbullah, what he'd expect is some form of justice, because he was unlawfully detained. What is the form of justice that is available in this act for a person who is unlawfully detained? Because you can't brand a person as a terrorist by mistake. You can't even call a person now. For example, politicians, at least in Parliament and other fora, they get extremely angry when someone accuses them of being corrupt or being a thief, right? You can't brand a person like that. Branding a person as a terrorist is one of the highest forms of insults that you can level at a person. So, for a person who is wrongly branded as a terrorist, despite who issues the detention order, be it the DIG or if he was further remanded by the order of someone else, what kind of repercussions are they facing? What sort of justice are you giving to people who have been illegally detained under the PTA? Because the justice that you've given the general public by detaining terrorists is almost negligible compared to the injustice that is happening to people who are unlawfully detained under these anti-terror laws. So what is the justice available in this act? If you say you've used Attorney at Law Hijaz Hizbullah as a case study for this act, what justice is available to him?
During his time, there was no such board of review where you can send immediately your petition.
No, I think
wait. Within 2 weeks' time, they should decide whether the detention order is correct or not. Then if it is so, then they can affirm the detention order. Otherwise, they will say they remand the person, or then they will discharge the person. That is what's the first step.
True.
What's the first step?
I don't think you, like, for a person who has suffered so much, a person who has not done anything, any terror-related thing, being accused of terrorism, spending a year and a half in prison, coming out. So you're saying, according to what you're saying, simply being released after being arrested and detained for an extended period of time for an offence that you have not committed is the only form of justice available to a person who is wrongly accused of being a terrorist.
Charlotte, you are talking about this Prevention of Terrorism Act or Anti-Terrorism Act. No?
Yes.
In other laws also, the penal code, the simple laws in this country,
But
how
you
many
have-
people were suffering? So you are not talking about those people. They just
let's
come
talk
out.
about them.
No,
Let's
no.
read.
But
We
I
are
think
talking.
overall, I think Shalan, what you're talking of is, I think there needs to be a system of compensation.
That's correct. I am
There has
told-
to be a system of
There should be.
compensation
There should be.
for those who have been wrongly detained.
That's
And
not only
not
detained,
yeah.
charged and then acquitted
There has to
or
be-
discharged by the detention order. They should be compensated.
I can just share an experience. One of the detainees who was with me at the New Magazine prison, he tells me that he dropped his daughter in the nursery and took the bus to Vaunia from Kilinochchi. And when he got off at the bus, he was arrested. He is going back. His daughter acquitted of all charges. His daughter has graduated. Now, of course, he has missed out all these years of his the enjoyment that he was looking forward to as a father to this child. And what does the state give him in return? There's no compensation. There's nothing. His only alternative is to file action in the district court and seek compensation, which nobody wants to do after 14 years, 15 years.
And how
16
can you
years
fund it?
Yeah, even if he can fund it, nobody wants to go to court. Nobody wants to on site near a courthouse, see the same faces of the people who did this to him. He doesn't want to. All he wants to do is go back home and live his life from wherever he left it. So that's the type of thing and that's where I think the state needs to get involved and provide a scheme of compensation for people, because they don't want to go back to court.
Yes, you are perfectly right. I say not only this PTA, you are talking about this PTA, thousands of cases where the people have been detained or they are taken into custody and charged, and then finally they have been acquitted by the High Court of Colombo or some other high authority. What happened? They just go home. And even, Charlotte, you must understand, even the judge of High Court, that is Mahanama Tilakaratne, was taken into custody by the police after recalling the warrant. I personally went there and I was chased away by the CID people. Now the lawyer representing client is being recognized in this particular legislative. In the Criminal Procedure Code or Judicate Act, it is not there. Only the police ordinance is there to consider that. But here, of course, it has been specifically stated that a lawyer can be there for the safeguard of this particular person. So that is why I say, ultimately, only the Bar Association came forward and got compensation for the judge to unlawfully detain in that particular, that is a High Court judge. So you are talking about a normal person. You are talking about Hizbullah. What he has not been compensated. So he was just there. Now he is there out of detained. But what happened? His long life. What happened to it?
Exactly.
So those things should be considered by the government when they give this type of legislation or this power to the police. They should know they will do injustice in some way.
Exactly.
So in that particular incident, situation, they should provide some compensation then and there, not after 15 to 20 years time. And that is why I say...
So would you be able, President's Counsel Ivar de Silva, to at least bring this to the attention of the authorities? Because none of them have been consulted. You're an advisor to the Ministry of Justice.
I wish the government consulted Mr. De Silva before drafting this law.
We have already discussed with that. So beyond our control, some people are there to give advice. So we are not going to go behind them and do these things. But what I say is, this should be considered. Otherwise, merely because you change the system, that does not mean down there is now Witness Protection Act is there, no? So only Witness Protection Act is for the witnesses, And what about the so-called accused or suspect who are there in the remand prison? They should be looked after. So they have been convicted in the Supreme Court and then they will go to jail. That's a different matter, right? But if they are being acquitted, so what will happen to them? So how the police officers should be charged for the illegal arrest and then having a case like that. So those matters should be there in this particular area, should be considered. So in future, like this, I feel that it should be done. When we are talking about Mandela's points with regard to detention of people, so now we have to consider those factors if they are going to go to the outside world and say we have improved the PTA by having this legislation. Now, at the same time, as they quite correctly pointed out, the people who are being suffered by the way of conducting the police, and then if they are acquitted or discharged from the proceeding, they should be compensated.
So we have one final question from Naresh,
Yes.
and then we'll go into the final
Mr.
round.
De Silva, on that point that you just made about compensation, there are many countries in the world which have systems of compensation where if you are wrongly incarcerated, then per day you are paid a certain amount of compensation. So, for example, now you see in the United States there's a lot of DNA evidence and so on, which is exonerating people who were convicted 20-30 years ago. And those people, yes, they don't get their lives back, but they do get at least a certain amount of money which will help them to live. So perhaps you can, what are your thoughts about recommending to the Ministry of Justice on that?
The Present Minister definitely will consider that factor, because he is going for that type of a legislator. He is considering the fact that people should be looked after well, and they should be given the opportunity to defend themselves. Once they being acquitted, they should be looked after by paying compensation.
So with that, we will go into the final round, unless, Ravindra, you have a question? No? All right. So let's make it to the final round. Of course, a very fruitful discussion, I think, personally. But of course, it's up to our viewers to decide. Let's see how the closing round goes. Of course, each of our panelists will be given a time of 2 minutes because we're very, very, very tight on time today. Let's start off with Attorney at Law Hijaz Hizbullah. Again, you were the case study, apparently, for this act. You think you've been a good case study?
I think I have been a good case study, but I think I have not been studied properly. I think the lessons have not been properly learned from the case study, and that was also my opening remark. I'm glad that my arrest and my detention has provided a platform for discussion of these topics. But the anti-terrorism bill is certainly not the improvement that we are looking for, and I totally agree with Dr. Gehan Gunatilaka in saying that this is a sophisticated piece of legislation, and in that sense we need to sort of congratulate the drafter for coming up with this sophisticated piece of law, because it represents this new style of rulership, new style of authoritarianism, and a new style of lawmaking. And I look back at something that was scrawled on the walls of the 4th floor of the CID. PTA is when injustice becomes law, and if that is PTA is where injustice becomes law, this is even worse. So my final conclusion, or my final point that I want to make to the viewers is that although do not get carried away with this reference to terrorism, because this is not about terrorism, this is about something else. The persons who are being targeted by this law are certainly not terrorists, and so certainly this is a much broader, wider law that's going to have much wider ramifications, not just today or tomorrow, but for maybe like the PTA for the next 40 years. So that is why this has to be opposed and fought back and pushed back to the utmost.
Thank you very much, Attorney at Law Hijaz Hizbullah. We may now move our attention to Bhavani Fonseca, Senior Researcher at the CPA, for her closing remarks.
So Shalini, I think today's discussion has been important in one sense. I think we all agree there are problems with this law. or the proposed law. And when we all recognize, including those advising the ministry, if there are problems, then a critical thing is to pause this process, have the conversations, be much more transparent and inclusive, and ask the question, who is this benefiting? And that's the whole point. Who is going to gain from such a law? And if you are to learn any lessons over the last 4 decades and more, is that we cannot take for granted that we can fix something when it's passed, because lawmaking process in Sri Lanka is so problematic. It benefits a few, it's within the control of a few, and the citizen who's meant to be protected by these laws get either targeted or inconvenienced, and possibly could be even labeled as a terrorist. So this law, in so many respects, while there may be one or two few things that are improvements, on the whole as a scheme is deeply, deeply flawed and should not be moving forward, and I think there needs to be a bigger discussion. That said, I think it's a bigger critique of the government that we have now. I think these questions have also come up about mandate, about rights, about democracy. And so in such a context where there are so many debates, so many contentions, we're trying to pass a law, and we're trying to pass another law on anti-corruption that is deeply problematic. And so it's the timing, it's the process, but the question of normalizing certain practices. These should be the exception. It's now being normalized, it's being legitimized. So in a few months, if this law passes, terrorism could be a very different concept for many people. So I will end with the fact that as it stands, this bill needs to be challenged, needs to be debated, and the government, if they're genuinely interested of the citizens of this country, should have that consultation and not ram through this at this moment.
Thank you very much, Bhavani Fonseca, Senior Researcher at the CPA. We now move our attention to Attorney at Law Dr. Gehan Gunathilaka. Doctor, before I allow you to make your closing remarks, I'd also appreciate it if you could elaborate a bit. This wasn't really touched upon during the discussion because we discussed so many things, but what should the international community really be doing with regard to this anti-terrorism legislation that is being proposed in Sri Lanka? Because they were the ones who demanded for the PTA to be removed, and I think President's Counsel Yuvar de Silva also conceded that this is a part of the efforts to show our responsibility as a country towards democracy, towards fundamental rights, to the international community, as a member of the international community. So if this anti-terrorism act is as bad as you say it is, what should the international community really be doing? The United Kingdom, the US, these countries that brought in resolutions against Sri Lanka on the grounds of violating fundamental rights. Should they just continue to lip service the concept of democracy, or is this all just a geopolitical gamble? As long as their intentions are fulfilled, anything goes. Your time starts now.
Yeah, that's a good question, because sometimes the international community can also get it horribly wrong, because some of these countries do have anti-terror legislation that are not worth emulating. So I think the best thing that the international community can do is to actually listen to the voices of minorities in this country, voices of civil society, voices of those who are out protesting, and amplify those voices. And I think if geopolitical interests can be set aside, and if the international community can really listen to those voices, we'll get the right answers. But often the case is that even governments from the West will adopt very problematic pieces of legislation. They will have better institutions that implement those problematic pieces of legislation.
So the institution fixes the problem.
I think you can say that. Whereas in countries like Sri Lanka, you can emulate those pieces of legislation. You can have model laws like the ICCPR that are still abused. So I would not trust expansive legislation of this nature with the current setup, because we can have even model laws laws that are modeled on international standards that are abused. But just going to my concluding remarks, I think you have to ask the question, what is the legacy of the PTA? It has been a tool of repression, a tool of authoritarianism, and it's been an instrument of abuse, particularly by law enforcement. Now, does the ATA cure those problems? The answer is no, because the ATA enhances those powers of law enforcement. If we take the premise that police officers have been in the business of abusing the PTA, then the ATA seems to be a strange answer to that, because we're enhancing the powers of the DIG, enhancing the powers of SSPs to actually even legislate. So the ATA is not an answer. It's just a repackaging of authoritarianism in a more sophisticated, elegant form. And I think, as Ijaz said, we might even congratulate the drafters for doing so. But the ATA, I think, is a failure if it is intended to be a better law than the PTA.
Thank you very much, Attorney at Law Dr. Gihan Gunathilaka. We now finally move our attention to President's Counsel UR De Silva, advisor to the Ministry of Justice. Of course, much was spoken of on this show. We had 3 panelists who were vehemently against the Anti-Terrorism Act, but you alone, sir, stood your ground. So your closing remarks, I will give you a little bit extra time, but of course, time is of short supply, and your time starts now.
It is unfortunate that we can't satisfy all people. So we have to listen to the international community, our community, as well as the so-called people who are there in the, these particular areas where they always think that when they introduce something and the government introduce something, social media thinks that is wrong. That is, they want to see something wrong in there. You can't have perfect legislation. But the fact remains, if you go through chapter by chapter in this particular legislation, you can see how the development would be, how the progress report is there itself. And if the case study was Hizbullah's case, and because of him, the most important areas had been considered, and the lawyer representative is a section, particular section was given for that. Section 43 is clearly stated that lawyer can do. What more you want? If the lawyer is there to get all the information, he can have the access, and the magistrate have the access, and then he will, if he has the private discussion with him, what more you want? This is the case, this is the law where you are considering a terrorist person. Whether he has done something wrong or not, it's a different matter. You can't take the exact person by going through here and there. If the authorities are so concerned, and if they have material with them, they can take that person into custody. So whether they are abusing that is a different issue. You can't blame for this particular act for that purpose. You can't change the brain of those people, the police officer. Earlier, they say that the president is giving detention orders. We are totally against that. So, after listening, as Bhavani said, they have listened to that and given power to DIGs. That is the police officer. Apart from the IG, DIG is the person who is controlling that area. So, if you have any problem with him, he will just merely for the sake of endorsing it, he will not do that. It is clearly stated that he should go through the report, and if he is satisfied, we will issue a particular detention order, and if he is not satisfied, then immediately he can write to the so-called Board of Review. Within 2 weeks, they should give their verdict. So why can't they talk about these things? So that is the first important area. Without waiting 3 months, they can do that. And after 3 months also, the magistrate, for the sake of endorsing it, no, he can't do that. He has to go through the report. I am totally against with this confidential report. It should be available to the lawyer. If the lawyer is being asked to make submission, how can he make submission without that particular report? So it should be available. 20 years hanging on his head is wrong. Those are the things that should be ignored. And then the death sentence
why they have put forward is the issue there. So those matters should be considered. If there are any progressive things that are there during the debate, certainly minister will change these things and then come out with that. But as a whole, it has gone beyond what we expected, because it has covered, it has ignored ASP's confession as well. So there is no other way of giving the opportunity to this person, because ASPs we are not in agreement with the confession recorded by the ASP. So the magistrate has the power. They say judicial power should be there. It is being recognized, and the magistrate being given the opportunity. Those factors should be considered. We can't expect everything to be done in one particular way. But if their suggestions are there, if those material can be considered, certainly the minister will do it. Minister will listen to that. We want a perfect, not the perfect thing, a better legislative for the people to get the maximum out of it. So what I would say, this gives a lot of hope to the people. For the sake of criticizing it, constructive criticism is available. It will be recognized. But for the sake of criticizing, if people are doing it, that is not for the country. This is for the individual people's satisfaction.
Thank you very much, President's Counsel UR De Silva. Given the fact that we invited quite a number of government representatives to be on our show, however, unfortunately, we were declined on many occasions, but especially thank you very much, President's Counsel UR De Silva, for representing the government, or at least the Justice Ministry that drafted this piece of legislation, given that we have so many panelists opposing this piece of legislation. One final question to you, President's Counsel UR De Silva. It's quite a short one, but given the current situation in the country, given the backdrop in which this piece of legislation is being brought, could you keep your hand on your heart and, not as a lawyer but as a Sri Lankan, say that this act is fair by the people and fair by the sovereignty of the people? Could you do that?
It's fair, quite fair. And then they have considered the Mandela's rules also when they are drafting this one. So we can just criticize it, but it has been considered. In any other law, if you can show that these things have been considered, I will say, I will withdraw my submission, but there are no. But there are some other things that can be considered, but not the whole.
But as a whole,
as a whole, it's a perfect.
It's fair.
It's fair, as you said.
And fair by the people's sovereignty.
Fair by the people's sovereignty, and we can go to the foreign countries and say we have done something to the betterment of the people. We have dragged from the this particular legislative PTA,
the draconian PTA,
and come to this one, and we are going to improve that also in future.
Thank you very much, President's Counsel UR De Silva, Advisor to the Ministry of Justice. Thank you very much, Attorney at Law Dr. Gehan Gunatilaka. Thank you very much, Bhavani Fonseca, Senior Researcher at the Center for Policy Alternatives. And thank you very much, Attorney at Law Hijaz Hizbullah, for joining us on our show. Also, many thanks to our journalist, Senior Journalist, Niresh Eliathambi. And I call him senior not because of the white hairs on his beard, but because of the years of experience and the wealth of knowledge that he brings to every show that he sits on. Thank you very much also, Attorney at Law Ravindu Jayakodi, for posing all the right questions. And of course, to our viewers, thank you very much for tuning in. It's important that you get involved. A lack of involvement on the part of the general public is one of the main reasons why we are here as a nation today. So let's get involved today, of course, for the betterment of Sri Lanka tomorrow and for generations to come. Thank you very much for watching. Take care. God bless.